A will or testament, commonly referred to as a last will and testament, is a legal declaration explaining how an estate or property will be managed after the writer of the will, called the testator, dies. Creating a will gives you sole discretion over what will happen to your assets, letting you decide who gets what. Generally, a last will and testament should contain the name of the person who will be in charge, called the executor, and ideally it will be typed or printed out, signed by the testator as well as witnesses. A last will and testament that reflects the wishes of a testator can provide the peace of mind that one's death will not cause additional unnecessary stress and frustration for the most important people in one's life.
Almost everyone should have a will, but most of us don't. And today, writing your will is easier than ever. You can even fill out your will online. If you're like most Americans, writing your will is pretty simple. If you have significant assets, however, or have blended families, you may need more assistance in writing your will since there may be a variety of legal issues to factor in. That said, here are some general guidelines for writing your will. First, take some time to gather information about all your assets. Make a list of everything you own that you'd like to leave to someone after you die. Now, this includes any interest in real estate, personal property, special family heirlooms, cars, bank accounts, and other investments, just to name a few. You might be surprised and find you have more to leave to someone than you thought. And this list will be very helpful to you when it comes to actually writing your will. Second, when drafting your will, you certainly can use a document preparation service, but make sure your will is complete. Handwriting something on a separate page may leave room for a challenge to the will. There could be a claim that someone other than you wrote that part in later. Now, third, try to be as specific as possible in your will so that your intent is perfectly clear to all parties involved and especially to the court. For example, you can certainly leave your car to someone, but if you mean a special car, you might indicate your 1956 Thunderbird. Fourth, it is usually best that all pages of the will be signed and dated. And finally, each state requires that you have witnesses sign your will to prove its validity, usually at least 2 witnesses. Now, ideally, the witnesses should have no interest in any property passing under your will. Now, even though it can be easy to write your own will, it is highly recommended that you consult an attorney, either early in the will drafting process or at least to review it once it's done, so you can be assured your will is valid under state law and meets your true objectives. Contact a wills and trusts attorney or an estate planning attorney for more information.
To create a will or a trust, you basically need 2 different things to come together, and I refer to them as formalities and intentionalities. Formalities are really just the form of the document itself. So a will, for example, it's one of the last legal documents that requires some very specific formalities on the document itself. So, for example, it has to be in writing. It has to be signed by the person who's creating the will, who we call the testator, and it has to be witnessed by 2 witnesses. Now, the interesting point is wills are never notarized, and a lot of people don't know that, but that's the formalities of creating a proper will. For a trust, it's a little different, because a trust doesn't have all those formalities. A trust actually can even be an oral trust, although that's very rarely the case, and you normally wouldn't want to create an oral trust, but you could. And for a written trust, it's very simple. You have a written document, and you simply sign it. Trusts typically are notarized, but that's not one of the requirements for a valid trust necessarily. So those are the formalities that you have to follow. But you also need intentionalities, and that is that the person who's coming to create the will or the trust, they have to intend to create that document. And there's a number of things that can stand in the way of that intent. So, for example, a person could lack capacity. And if they lack capacity, then they wouldn't have the intent to create that document. There also can be things like undue influence. So if a person is creating a document out of the undue influence, then it's not a validly created document. There can also be fraud, and there can even be duress. But if you have somebody who actually creates a will or the trust, they express that intent to create the will and trust, and they're not suffering from any of the capacity or undue influence or fraud type issues, then you have a scenario where you can have a validly created document, whether you're creating a trust or a will.
More people today understand the need for a will, but still aren't sure when they should actually consult an estate planning attorney. But if you have any assets to pass on to the next generation, consulting an estate planning attorney is a good idea. An attorney can not only help you figure out the best plan for transferring your assets to your heirs, but can also help protect those assets after your death. Contact an estate planning attorney and ask for a general consultation to learn more about what options would be best for your situation.
Finding an attorney to effectively manage your estate during your life and properly allocate your assets upon your death is not always easy. First, you want an attorney who is properly qualified and has sufficient experience in trust and estate planning. Second, they should be backed by credible accolades such as a lead counsel rating and be able to show sufficient ratings and client reviews. Third, your attorney should be a good personality fit and conform to your needs as far as availability and communication. Fourth, be sure to discuss if there is an initial consultation fee and what type of payment plan they require. Finally, your attorney should be transparent regarding how they can plan for your estate and manage it.
It can be a lot of work to be an executor of an estate, which is why each state allows executors to collect fees in exchange for performing their duties. In simple cases where there is unlikely to be any disputes among the heirs, a friend or relative may be able to act as the executor of an estate, and these people usually waive their right to a fee. But executors of more complicated estates typically do collect their fee. Executor fees are usually set at a percentage of the value of the estate, typically around 4% for a small estate or more for larger ones. The fees also vary depending on state law.
There's an interesting interplay between undue influence and lack of capacity. On lack of capacity, you actually have to prove that the person lacked the capacity to create the document that you're challenging, whether it be a will or a trust. So you have to go to the medical records, and you have to have expert witnesses, and you have to have all this evidence come in, and you have to try and prove that that person simply could not create that trust or will. It can be very difficult to actually prove in court. Not impossible, but difficult. With undue influence, you're not proving that they lack capacity, you're just showing that they had a weakness of mind that then made them susceptible to undue influence. It's not as hard to prove because you're not showing that they were completely incapacitated, you're just showing that they were weakened, they were in a weakened mental state. And that can be enough to successfully prove undue influence. And so that's the interesting interplay between the two. And undue influence doesn't get a whole lot of attention because people focus more on the lack of capacity. But the lack of capacity is actually harder to prove in court, oftentimes.